Welcome to Personal Planning. This webinar is aimed at people who are living with dementia themselves or who are caring for or connected to someone who is living with dementia. If you find you have questions about anything you hear in this recording, please don't hesitate to call the first linked dementia helpline at 1-800-936-6033. And the numbers will also be on the last slide. We're going to look at the following areas. We'll start by defining what we mean by personal planning and look at the importance of planning as early as possible. We'll spend some time reviewing what personal planning looks like in BC and the legal tools available. We'll share some resources with you to help you with your personal planning, and then talk about some areas that are covered in other recordings, primarily safety. So what is personal planning? It's making arrangements for a time when a person will need help managing their personal affairs or when they're no longer able to speak on their own behalf. It covers all areas of your life: healthcare, personal care, legal affairs, and financial affairs. Every adult in BC should have documents in place appointing decision makers for legal, financial, personal, and healthcare decisions in the event they can no longer make decisions for themselves. Putting these documents in place early is beneficial because it will reduce your future stress and minimize potential crises. Personal planning as early as possible is also important because many of these documents require mental capability and capacity, which change as dementia progresses. The process of personal planning can be uncomfortable as it requires you to consider what you would want when you're no longer able to make decisions or speak for yourself. This may mean considering distressing situations and having difficult conversations, and it's not something that most people want to do. However, personal planning now means less distress in the future. This isn't something that you simply decide to sit down and do all at once. You have to put some thought into it, and it's quite a long list of things, and so it's best just to focus on one thing at a time. Start with conversations, which, although difficult, may mean fewer issues in the future. Because dementia progresses differently for everyone, it's difficult to predict how and when your abilities will change and what your needs might be in the future. However, by planning in advance, you can prepare to manage your future no matter what changes occur. Knowing you have a plan to be safe and well cared for, and that your wishes are known and will be respected, can reduce anxiety and crisis situations in the future. In addition, your decision makers, family members and caregivers, will have the confidence to know they're doing the right thing and honoring your wishes. Being incapable of making some decisions does not mean that a person is incapable of making all decisions. However, it can affect the type of legal documents that can be made. It's best that planning take place while a person living with dementia can participate in the decision making and has what's called mental capacity to make legal and financial decisions. Mental capability, sometimes called mental capacity, is a legal term that refers to someone's ability to fully understand the meaning of what is being decided. It is not a medical test or a medical term. It's up to the lawyer or notary to decide whether the person is capable of signing a legal document. Because there's no standardized tool that's required, the decision regarding a person's capability can vary by lawyer or notary. The law will not recognize or enforce the decision of a person who is not considered mentally capable of understanding the nature and consequences of that particular decision. If you want more information on how a decision about capacity is to be made or has been made, consult with a lawyer or a notary, and they may in turn seek the input of a doctor. Again, if personal planning is done early, it allows a person living with dementia to participate in the planning, which again, not only does this give the person a sense of control over their own future, it can also reduce stress for those making decisions for them by allowing their wishes to be known. Now is the best time to learn about the tools that are available to you. Early planning can give caregivers and family members the confidence to know that they're doing the right thing by honoring the person with dementia's wishes. Knowing the person's wishes on health matters can help reduce the chances of future family disagreements. Our goal is to help motivate you to start thinking about personal planning now so that you can learn where to get information and support for putting together your planning documents. Always seek professional advice when necessary. So in British Columbia, there are two broad types of personal planning, future planning. There's the estate planning, what we often think of when we think of future planning. That's our will, and that's concerning what will happen after you've died. But personal planning is for what happens during your life. And today, this session is talking about the tools for personal planning during your life. So in British Columbia, you may also come across the term advanced care planning, and that would sit just beside the health box, just as kind of a little sub box off the health box. This term is used by the healthcare system, advanced care planning, and focuses on the healthcare aspect of personal planning. In contrast, personal planning involves all areas of life: health, personal, legal, and financial matters. Just to quickly define them, healthcare concerns decisions about medical care that you want to receive, including things like resuscitation orders and information about blood transfusions and feeding tubes and the like. Personal care is an area of authority that can only be covered in a representation agreement in British Columbia. It can include things like shelter or living arrangements, where you live and with whom, assessment and planning for support or services, diet preferences, exercise, spiritual matters, care of pets, personal safety and contact with others, participation in activities. Legal and financial matters are often what we think of when we think of future planning, and they're covered in two documents that we'll discuss shortly. It's important to understand that in British Columbia, no one document covers all four aspects of personal planning. There are two different personal planning paths for individuals in BC, and different legal documents that are used depending on the path you are on. The path of those who are planning for the future, that is, for people who understand the nature and consequences of decisions at the time that they are making those decisions, is one of the paths. And the second is the path of those who need help today, that is, for people later in the journey whose capability is already under question. So the first personal planning path we're going to talk about is for those who are planning for help in the future. This path is for adults who understand the nature and consequences of their planning documents at the time that they're making them. and it includes a representation agreement, Section 9, and an enduring power of attorney. The enduring power of attorney is a legal document that appoints someone to act on your behalf for financial and legal matters. Adults who understand the nature and consequences of the documents that they're making will make, as I mentioned, the two documents, an enduring power of attorney and a representation agreement, Section 9. So an enduring power of attorney, or EPA, allows one person, called the donor, to appoint one or more people, called the attorney, to make financial and legal decisions on his or her behalf, for example, banking or property management. And because it is an enduring power of attorney, even if the person, the donor, becomes mentally incapable, the attorneys can still make legal and financial decisions on behalf of the donor. An enduring power of attorney does not give authorization to make healthcare or personal care decisions. A representation agreement is needed for this, and we'll talk about that in a little bit. We strongly encourage that families consult a lawyer or notary public for assistance when preparing an enduring power of attorney. And you may look down below the recording, and there are links to nidus.ca and information on the Nidus website about an enduring power of attorney. A representation agreement is BC's legal document for appointing someone who can make health and personal care decisions on another's behalf. A representation agreement appoints another person, the representative, to make these decisions when the person making the agreement becomes unable to make those decisions for themselves. For example, decisions about medications, tests, surgery, dental and eye care, care home placement, what kind of recreational or therapeutic activities the person should be involved in. This agreement must state explicitly if end-of-life decisions are included. Most people would appoint a spouse or partner, family member, or close friend. You may name more than one representative. If you do this, you'll need to decide if your representatives may act independently or must always act together. There are two different kinds of representation agreements, and they are effective immediately upon signing. A Section 9 is used when the person making the agreement is considered to be capable of understanding the nature and consequences of their decision. A Section 7 is used when the person with dementia is considered no longer capable of understanding the nature of their decisions. One thing to note here is that a living will is not a document that is legal in British Columbia. Living wills are legal in many other provinces in Canada, but not in British Columbia. This is a way of expressing a person's end-of-life wishes, and in British Columbia, the legal options available to address healthcare wishes for end-of-life situation are a representation agreement or an advance directive. A Section 9 representation agreement requires that the person be mentally capable at the time of signing. That is, that they understand the nature of what is covered in the legal planning document they're making, and they understand the consequences of authorizing someone to act on their behalf for health and personal care. A Section 9 representation agreement does not cover financial or legal affairs, nor Does it authorize a representative to do anything that is prohibited by law? A free basic RA9 Representation Agreement Section 9 RA9 form is available on the NIDAS website. It includes a set of instructions for how to complete the form. NIDAS also offers a 20-minute information appointments over the phone for personal help. They do not give legal advice. The fee is $25 or a sliding scale for low income and can be booked on their website at www.nidus.ca. In BC, if you are deemed incapable of giving or refusing consent for health care, a healthcare provider must get consent from another authority, for example, your representative in your representation agreement. An advance directive can also act as an authority. When drafted and executed properly, an advance directive is a legal document in which a person sets out their wishes about the kind of medical treatment they do and do not want in the future if they become mentally incapable and a healthcare decision needs to be made. It's only used for health treatment decisions. It may be useful for people without a friend or family member that they would feel comfortable appointing as a representative to make decisions on their behalf. An advance directive can be important if the person knows a type of health care that they do not want under any circumstances. For example, some people do not want blood transfusions, even if they will die as a result. However, we strongly recommend having a representation agreement even if an advance directive is made, because circumstances can change and not all situations may have been considered or known at the time the advance directive was made. For more information on how to make an advance directive, refer to a handout that you can download from NIDAS or see the link below the recording. The medical orders for scope of treatment, or MOST form, is not a legal document. It's a tool used by physicians to communicate medical orders to an ambulance team, your healthcare team at a hospital, or healthcare staff in a long-term care when you are unable to. Medical orders are essentially your doctor's orders for medical treatments and interventions, for example, CPR or do not resuscitate, intubation, those kinds of things, based on conversations that you and your doctor have had about your values and healthcare goals. It includes information on drug and food allergies and a person's capacity to speak on their own behalf. It can also mention who your named representative is, for example, a temporary substitute decision maker if you don't have a representation agreement in place. The MOST also alerts healthcare teams to personal planning documents that have been made, such as an advance directive or representation agreement, and it can help ensure that your wishes are respected in an emergency situation. It's completed by physicians for adults who have a life-limiting chronic condition such as dementia, and begins with a conversation between patient and physician about the person's wishes. It can be changed at any time, such as after a change in health status, or a change in wishes for medical treatment, or upon moving into assisted living or long-term care. It's strongly recommended that you keep a copy of the form at home and make others close to you, for example, your family members, aware of it. Keep a copy on your refrigerator so that it's easily accessible for first responders. So those are the tools that are used if you're planning for help in the future. If we're looking to plan for help now. So if the person's capability to understand is in question at the time of making their planning documents, you'll want to consider making a representation agreement section 7 or RA7. This is a legal document for adults who need help today. It allows an adult whose mental capability is in question to give certain authorities to a representative. In addition to health and personal care, and unlike Representation Agreement Section 9, a Section 7 includes some legal and routine financial affairs. There are 4 areas of authority: major and minor health care, for example, medications, tests, dental care, surgery; personal care, living arrangements, diet, types of therapeutic activities; basic legal affairs, so obtaining legal services or settling an insurance claim can be done with an RA7; and routine management of financial affairs, banking, government benefits, completing and managing income tax assessments, managing investments, and redirecting mail. It does not require notarization or legal professional, although consulting with a lawyer or notary is highly recommended to ensure there are no loopholes. It also does not include certain financial authorities, such as dealing with real estate, using or obtaining a credit card or a line of credit for the person. Again, a free standard form with instructions are available on the NIDAS website that can be used to ensure that the representation agreement being made meets the requirements for a valid legal document. A less desired way of looking after your rights if you are unable to make decisions for yourself is through something called committeeship. The committee of a person is when an adult guardian is appointed through a court order. It's primarily used in 3 situations: where no planning has been done and decisions need to be made; where planning has been done but the plans have fallen through. For example, the person appointed as a representative on a representation agreement is no longer willing or able to act. Either they've become incapable themselves or perhaps they've died. Can also be in situations where family members have different goals. They are unable to work together as a team and/or are in disagreement. An RA7 or RA9 and EPOA, enduring power of attorney, so a representation agreement and an enduring power of attorney, are highly recommended as legal alternatives to committeeship whenever possible. A family member or a friend may apply to the court to be appointed committee of the person for health and personal care, and/or committee of the estate, which is for legal, financial, and business affairs. It can happen that, for example, a case manager may also apply to the court if they suspect a legally appointed decision maker, for example, a family member with an enduring power of attorney, is mismanaging the person with dementia's finances. Often, both committee of the person and estate are applied for at the same time. The public guardian and trustee will explore all possible alternatives before proceeding with committeeship. Committeeship involves going to court, and that involves a great deal of time, money, and paperwork. It's very expensive and it's not advised, but we bring it up so that you're aware of it, and know that if all else fails, there is a fail-safe. The public guardian and trust. The Office of the Public Guardian and Trustee in British Columbia is the fail-safe. So if a person is incapable of giving informed consent, as mentioned earlier, a healthcare provider must get consent from one of the authorities mentioned below and in this order: committee of person, a representative, so the person you chose and authorized in a representation agreement, an advance directive, and a temporary substitute decision maker. Healthcare providers are required to seek instructions from a legally appointed decision maker. In the absence of a representation agreement, there are still processes in place for qualified family members and friends to be granted authority to make decisions on a person's behalf. Making a representation agreement ahead of time is absolutely the best. Even if, however, there is not a representation agreement in place and you are a family member or a close friend, if you have concerns, if you are the care partner and have concerns about health care being delivered, speak up and let people know your concerns. So, if an adult doesn't have a legally appointed substitute, such as through a representation agreement, then the healthcare provider will select someone to be the temporary substitute decision maker, the TSDM. And there is actually a list that is outlined in the law, starting with your spouse and going down through family members, other relatives, all neighbors, people that you worked with. They really look hard for someone who knows you. In some cases, if no one from the TSDM list is available or considered qualified, or if there is a dispute, the public guardian and trustee can authorize who will be the TSDM, or the public guardian and trustee staff will be the decision maker. A TSDM must carry out instructions or wishes provided to them verbally or in writing by the person when they were capable. They only have the authority to make certain healthcare decisions. For example, a temporary substitute decision maker can only refuse life support if most of the medical team agree that it is medically appropriate. They also do not have legal authority to make personal care decisions, for example, where the person will live, support services. The only way to authorize a person to speak on your behalf is through a representation agreement. Representation agreements are particularly helpful if there are issues with family dynamics. So, looking at a summary of the planning tools, again, there are two routes, two paths. Planning for the future is for adults who understand the nature and effect of their planning documents at the time that they are making them. And there are three tools on this path: the enduring power of attorney, a representation agreement section 9, and an advance directive. And you do not need all three, though you can use all three and they can work together. Planning for Help Now also has three documents. However, in this case, you'll likely only need one. So it's for adults whose capability to understand is in question at the time that they are making their planning documents. And they include a representation agreement section 7, a committeeship, or temporary substitute decision maker. Planning for the future, an enduring power of attorney and representation agreement section 9 is strongly recommended, and an advance directive can be appropriate when the person is sure of specific healthcare measures that they would or would not want, as mentioned, for example, like blood transfusions. A limitation of an advance directive is that it may not include all possible scenarios that can arise later on when healthcare decisions need to be made, and a representative, a living human being who knows what you want, may be better able to judge what you would prefer. Planning for help now, a representation agreement section 7 is recommended. And as mentioned, this can reduce the potential of family disputes if a temporary substitute decision maker needs to be made. There are some additional resources and links are provided below the recording. So personal planning along the dementia journey is essentially a good checklist of important planning suggestions of what you may want to consider. It includes information on financial and legal affairs, health and personal affairs, and resources where you can get more information. Navigating the system is essentially a flow chart of all of the different columns of support that you may access and may want to consider, from assessment, getting a diagnosis through family doctor or specialist, all the way through to care facility, Alzheimer's Society, the services that we offer, a whole variety of things. My Voice is a guide put out by the Ministry of Health in 2013, specifically about advanced care planning. And while it may not be, while you may not want or need an advanced care plan, this document is an excellent resource for considering questions that you may not have thought of. And looks very carefully at a number of different health decisions. There is a link to the document below. The Society also produces an annual guide to income tax and benefits handouts. It provides information on some of the tax benefits that people with dementia and caregivers may be eligible for. Income tax rules are complicated and they change each year. It's recommended you consult with a professional, like an accountant, for more information. NIDAS, I've mentioned a couple of times, is a nonprofit organization devoted to personal planning in BC. It provides information, resources, and webinars on personal planning tools. And as mentioned, they offer consulting appointments to answer your questions, such as what forms you'll need based on your circumstances and where to get them. They'll also provide tips for using your planning documents. This following advice is general and can be applied to all sorts of professionals involved with personal planning, including lawyers, physicians, and case managers. Information and policies are constantly changing, so it's really important to ask a lot of questions to find out the information you need and to clarify the information you have to ensure it's the most accurate. Questions you may want to consider include: who should I speak to? What does the law or policy say? When can I expect to hear back? Or when should I follow up? What are the next steps? Write down questions as they come to you so that you're prepared for meetings or appointments. Try to prioritize the questions in order of importance to ensure you get the ones more important to you answered in the time that you have. And don't be afraid to speak up if something doesn't sound right to you or if you don't agree with a decision. It's okay to seek a second opinion. For example, disagreeing with a physician's determination of a person's fitness to drive, or a lawyer's assessment of a person's capability to make informed decisions. Having a friend or family member, could be a child, could be a neighbor, accompany you to a meeting or appointments as a note taker can allow you to focus on the conversation. But whether it's you or someone else, take notes on the content of the conversation, on the questions that arose, the names of whom you spoke with, and the date of the conversation. Try to keep your notes all in one place. If an issue arises later on, it'll be helpful to have organized notes to refer back to. Be firm with your concerns or requests for information, but stay polite. Acknowledge the efforts made by the other person, even if they're not clear. For example, I understand you have a very busy workload, and I appreciate your effort in finding a space in an adult day program. However, I'm increasingly finding it difficult to manage during the day, and I'm concerned about my own health if the situation continues. Is there any way my position on the wait list could be revisited? Don't be afraid to be honest about how you're feeling, depending who you're speaking to. For example, when speaking to a lawyer, it's best to keep the conversation focused on the facts. But while healthcare professionals also need clear facts in a conversation, be honest about your feelings if you're finding a situation difficult. In some cases, how you're coping as a caregiver can play a significant role in the decision of what services that are offered to you. If you are being told that's what it's like for everyone, call a staff member at the Alzheimer's Society of BC to talk about advocacy and avenues for appeal. Your experience is your own, and no one else can tell you what your experience is like. Persistence pays off. So other areas to consider, and there are some additional recordings in this series. So conversations about personal planning. Driving and dementia. There are a number of things to consider. We know that dementia is a progressive illness, and as a result, there will come a time when driving will have to stop because of the changes brought about by dementia. So reviewing the information on driving and dementia. And then the area of personal safety, wandering, traveling with dementia, and abuse concerns are another areas to consider. So personal planning is a very, very large topic, and we've just touched on some of the pieces. As mentioned, there are other videos in this series with tips on talking about it, driving in dementia, and other areas of personal safety. It can feel overwhelming, but don't look at the whole part. It's like that old saying, how do you eat an elephant? One bite at a time. By focusing on one area, one conversation, you can work your way through all the pieces. The important thing is to start. Thank you for reviewing this information. As mentioned, there are links below this recording to information and documents that are referred to. And if you have questions or concerns, don't hesitate to contact the first link Dementia Helpline. In English at 1-800-936-6033. In Cantonese or Mandarin at 1-833-674-5007, or in Punjabi at 1-833-674-5007. 5003.